Thank you for coming today. I'm Rick Harnish. I'm the Executive Director of the High Speed Rail Association. We've got Chris Ott, our Deputy Director up in Madison,
Hi, everyone.
and John Anderson, who's the counsel at Metra in Chicago. For those who aren't aware of us or are new to the game, the High Speed Rail Alliance is a nonprofit advocacy organization. We help people like you all around the country understand why we should build high-speed regional rail, what it is, what steps need to be taken in order to make it a reality in this country. And then we help you by giving you the tools you need in order to educate your leaders in your state capitals or in Washington, D.C., so that we can have this wonderful service here in the States. One of the bigger challenges that we need to come with a federal solution to is liability in case of accidents or other issues. And it's an issue that the Commuter Rail Coalition has been working on extensively over the past year or so. And so John has been gracious enough to come and talk to us about what those issues are for commuter rail agencies and what we need to do in order to get it fixed. Chris, is there a more formal introduction?
There is. We've been talking with John for probably at least a month now about this, and he provided his bio, which I will share with everyone right now. And thank you all for joining us today. Here is John's background. R. John Anderson is a Chicago-based trial lawyer with more than 40 years of experience defending railroads, corporations, and insurance companies. He is currently a Deputy General Counsel in the Law and Risk Management Department at Metra in Chicago, where he supervises litigation, claims, and insurance. Before this, John held positions at Metra as Senior Trial Counsel, Director of Risk Management, and Senior Director of Litigation and Risk Management. And before joining Metra 15 years ago, John was a partner in a mid-sized Chicago law firm. For the audience members, if you have comments, you can put those in Zoom's chat feature. If you have a question, please use Zoom's Q&A feature. That just sort of helps us to keep things organized and separate. I will, as soon as John finishes his presentation, I'll be sharing with him the questions that you all have put in the Q&A, and we'll get to as many as we can. And with that, John, thank you again for being here, and we'll let you take it away.
Thanks, Rick. Thanks, Chris. Good afternoon, everyone, and thank you for attending. Today, I'd like to discuss railroad liability, particularly the list you'll see in a second. We're going to try to cover approximately 235 years of law in about 35 minutes. So it is indeed a very brief and 35,000 foot view of railroad liability. Today, I'd like to discuss sources of law, liability, negligence, nuclear and thermonuclear verdicts, as well as how to protect ourselves and mitigate these risks. Let's start at the logical beginning with the Constitution. The Constitution was written in 1787. It was ratified in 1788 and implemented in 1789. It was meant to be a dynamic, living document. It has been amended only 27 times in 235 years. The last meaningful amendment was passed in 1971. I like historical footnotes. One such footnote is the actual last ratified amendment was introduced on September 25th, 1789, and remained pending for 202 years, 223 days until finally passing in 1992. This amendment had to do with congressional salaries. We tend to think of constitutional rights in terms of individual freedoms like speech, religion, right to bear arms. But for our purposes today, the most important part of the Constitution is the Commerce Clause. The Commerce Clause gives Congress the power to regulate commerce with foreign nations, among states, and with the Indian tribes. This was tested a few times in recent centuries. In 1824, in the case of Gibbons versus Ogden, interstate activity, the Supreme Court, I should say, indicated that interstate activity could be regulated under the Commerce Clause, and provided that the activity is part of a larger interstate commercial scheme. So even though the commerce was interstate, if it affected interstate commerce, the federal government could regulate it. The Supreme Court in Swift versus the United States in 1905 went a little further, saying that Congress could regulate local commerce, again, as long as that activity could become part of a continuous current of commerce. From the Constitution, we get our laws. It's legislative laws, and it's codified in the United States Code. Historically, working for a railroad was, in the 1800s, one of the most dangerous jobs in America. It was a close second only to mining. Railroads, consequently, were the first industry subject to federal regulation after decades of public outcry about safety. This was the Interstate Commerce Act passed in 1887. Consequently, railroads are one of the most heavily regulated industries in the United States. In fact, railroads are referenced 1,409 times in the United States Code. Just to give you an idea of some of the legislative acts and the power of Congress over railroads, the Pacific Railway Act passed in 1862. I like the language here. It offered government incentives to assist, quote, men of talent, men of character, men who are willing to invest, that's probably the most important part, in developing the nation's first transcontinental rail line. The Hepburn Act in 1906 granted federal regulators in the ICC the power to order railroads to set reasonable rates, and even empowered the president himself to monitor railroad pricing. In 1926, the Railway Labor Act was passed. This was an unusual act as well, because this is where Congress gets involved in major labor disputes involving the creation of changing of collective bargaining agreements on rates of pay, work rules, and working conditions. So very much a micromanagement act. Specific to rail liability are a number of other acts. One of the most important, of course, is the Federal Employers Liability Act passed in 1908. It governs the right of railroad employees who are injured, become sick, or killed in the course of their employment through an employer's negligence to sue the employer for damages. This is very different than workers' compensation. It predated workers' compensation. And unlike the administrative process that we see in workers' compensation, the Federal Employers Liability Act, FELA for short, allows suits in court where a wide range of damages are obtainable. FELA, as we'll see later, also provides for liberalization of the rules for determining tort liability. And as I just mentioned, allows for monetary payments that we don't see in workers' compensation, like for pain and suffering. The Safety Appliance Act of 1893, I've seen it written as being passed in 1900 as well. This is another congressional thing. It was originally entitled "An Act to Promote the Safety of Employees and Travelers upon Railroads by Compelling Common Carriers Engaged in Interstate Commerce to equip their cars with automatic couplers and continuous brakes, and their locomotives with driving wheel brakes, and for other purposes." So that was subsequently shortened to the Safety Appliance Act. Now, what it really did, though, was address the lack of uniformity among the states regarding handbrakes and couplers. In the 19th century, if you can imagine traveling across country, going through a number of states, and all the rules for the railroad were different. So the Safety Appliance Act tried to make things very much one set of rules that the railroads could follow. Safety must-have features from this act on cars and locomotives today we take for granted. I mentioned train couplers earlier. What the act mandated was train couplers that can be coupled by impact and uncoupled by pulling the cars apart without a worker having to step in between the ends of the car. To illustrate that, this is a early coupling system. It is an eye and hook setup, excuse me. And as you could see, the trainman there is actually standing in between moving cars, trying to link these two together with the hook and eye. As a result of the act, this is what we have today. The cars bump up against each other and the couples couple together. The Safety Act, again, things we take for granted today, spoke about running boards and ladders and handholds and grab irons that had to be on the car. Imagine trying to jump on a car without those things. And power brakes for the engineer to control the entire train speed without using handbrakes. I think we've all seen the old Western movies, and here's a photographs of a brakeman doing what seems to be the second worst job in the country after coal mining, actually standing on the cars as they're moving. And the next slide, one is an illustration of some poor train brakeman atop a car. It looks like in the dead of winter in the ice and snow. And the picture on the right, clearly in the mountains. And can you imagine trying to slow or stop a downhill train in the Rockies in the middle of winter while sitting or standing on top of a car like that? Other legislative acts include the Boiler Inspection Act, also known as the Federal Locomotive Inspection Act of 1911. This one, and you're going to see this a lot as we go through the presentation today. This act imposed an absolute duty upon the railroad to furnish and maintain the parts and appurtenances of their locomotives in a safe and proper condition. There are special considerations under the Locomotive Inspection Act. Locomotives must be in use. There is a ton of case law on whether a locomotive is in use or is not in use. Workers must be operating or maintaining the locomotive. For electric lines, all units that are self-powered are deemed to be a locomotive. And the act was expanded to include, and this was mostly by the courts, have ruled that long-term illnesses such as becoming sick from diesel exhaust and asbestos can come under the Local Inspection Act, as well as things that happen near the locomotive, like slipping on oil or ice. Another safety act is the Federal Railroad Safety Act of 1970. This was created for the purpose of giving regulatory rights to the Federal Railroad Administration. Any area of railroad safety falls under the realm of the FRA. Some of the regulatory acts that guide the FRA are the Signal Inspection Act. This one, besides the physical signal, also requires minimum standards for signalmen. They must either have a Bachelor of Science degree in electrical engineering or 4 years experience. The Accident Reports Act is exactly that. We are required to report every single accident to the FRA that occurs. The Safety Appliance Act we discussed a little bit already, as well as the Locomotive Inspection Act. The Federal Railroad Safety Act protects railroad employees from, and this is very different too, wrongful termination, suspension, and demotion. So it's not just physical injury now. Now we're getting into how the railroad workers are treated. It provides whistleblower protection. This one seems obvious, but it requires prompt medical attention if a railroad worker becomes ill or injured while working on the railroad. And again, it allows the railroad worker to collect damages. I just wanted to mention briefly the Railroad Safety Act of 2023. I think what this act does, which was passed fairly shortly after the East Palestine, Ohio derailment last year, it was passed quickly, and it has a number of regulations for freight railroads to increase the safety of the roads, particularly with respect to wayside defect detectors. The bill also requires a minimum 2-person crew for certain, not all, but certain freight trains. They looked at tank cars. They are phasing out certain railroad tank cars by May 1st, 2025, which is 4 years sooner than required under the prior law. Expands training for local first responders and provides funding for research and development to improve railroad safety. Next, we come to the Code of Federal Regulations. These are rules that are legally binding. They are derived from the United States codes. But as I mentioned, they have the effect of law. To sum up these sources of law, the United States Code is approximately 60,000 pages long, contained in 54 volumes. The Code of Federal Regulations is approximately 200,000 pages long and contained in 242 volumes. Someone needs to interpret all that stuff, and those are the judges. The judges interpret the written laws as applied to the facts of a case. Interestingly, the judges' written and published appellate decisions in turn actually become law in their own right. So the remainder of the presentation is focused on the court system. And you want to just talk briefly about liability and negligence. To be negligent, you need 4 things. You need to have a duty to the person who claims to be injured. You have to breach that duty. There has to be a causal connection or proximate cause between your act and the person's injury. And of course, that person actually needs to be damaged. If one of those elements is not proved in court, the injured person or the plaintiff will not recover anything. Negligence and liability are 2 different things. There is a difference between them. You can admit being negligent, but you can deny liability. Liability, again, focuses on that causal connection. To illustrate the difference, we're going to be looking at some Illinois jury instructions. This is the first one I'd like you to look at. It's about proximate cause. And it says proximate cause is a cause that in the natural or ordinary course of events produced the plaintiff's injury. Here's where it gets interesting. It need not be the only cause, nor the last or nearest cause. It is sufficient if it combines with another cause resulting in the injury. So when we talk about liability, we talk about, I'd like to talk about 5 areas of liability today. One is passenger liability, where railroads owe the highest duty of care. Third-party liability, these are grade crossing accidents with vehicles or pedestrians, injuries on platforms, things like that. Strict liability, which arises statutorily from some of the acts we looked at previously. Liability under the FELA and contractual liability. So first, let's take a look at passenger or common carrier liability. Common carriers are railroads, planes, ships, buses, taxi cabs, limousines, amusement park rides, elevators, and escalators, generally speaking. The relationship of the passenger and carrier exists only when the person is in the act of boarding, is in or on, or is leaving the carrier's vehicle. A common carrier, pursuant to this jury instruction, is not a guarantor of the passenger's safety. We don't have to guarantee their safety, but we do have a duty to our passengers to use the highest degree of care. This is an interesting instruction involving intoxicated individuals. When a carrier is aware that a passenger is intoxicated so that the hazards of travel are increased as to him, it is the duty of the carrier to provide that additional care. So care even more careful than the highest duty of care when you have someone who's intoxicated on the train. Turning to third-party liability, we're back to negligence. Negligence is defined as the failure to do something which a reasonably careful person would do, or the doing of something which a reasonably careful person would not do. The law does not say how a reasonably careful person would act under these circumstances of the case, and it says that is for you, the jury, to decide. It's interesting that in a way, they leaving the decision to the jury is not really an instruction. It doesn't say if you don't shovel your walk, that's a problem, they're liable, they're negligent. It lets the jury decide what the negligence is, and that comes into play when we look at verdicts later. This is not the highest duty of care to people in a grade crossing or honor platform. This is ordinary care. And for ordinary care is simply the care a reasonably careful person would use under the circumstances. And again, the instructions really do not instruct. They say the law does not say how a reasonably careful person would act. So our duty, again, is for ordinary care, not the highest duty of care as we see with passengers who are on, getting off, or boarding our trains, but these are the third parties that we encounter along the way. It is true that often the people who sue railroads contribute to their own injuries, and for that, there's instructions on contributory negligence. And contributory negligence is a negligence on the part of the plaintiff that proximately combined to cause the alleged injury. There are three different ways in different jurisdictions on how to handle contributory negligence and comparative fault. The first way is really kind of harsh. That is, the plaintiff receives nothing if he is at all contributory negligent to his own injury. The second that we have in Illinois is a modified comparative fault system, whereby if the jury finds that the plaintiff was 51% contributory negligent to his injuries, then he doesn't get anything. Under 51%, he gets something. And then there's a pure comparative fault jurisdiction where the plaintiff recovers minus the percentage of fault that the jury attributes to him. FELA is a pure comparative fault system. We had one case at Metra a number of years ago where the plaintiff was found 95% at fault. The award was something like $100,000 with 95% contributory negligence assessed. The plaintiff walked away with $5,000. Let's take a look at liability under FELA. It says here, it was the duty of the railroad to use ordinary care, that's fine, to provide its employees with reasonably safe and suitable tools with which to do their work. This first bullet point is a catch-all. We have encountered, and I'm sure other railroads have as well at Metra, slip and falls is a failure to provide a safe place to work. We had a spot, or a case rather, where a windshield wiper was stuck. The engineer tried to unstick the windshield wiper and tore his rotator cuff. Stepping in a hole was found to be negligent by the court. Cleaning snow off the car, tripping on a throw rug was also a problem for not providing a reasonably safe place to work. The second bullet point are tools. We have an obligation to provide safe and suitable tools. They don't have to be the latest tools or the best tools, but they have to be reasonably safe. One of the problems that we encounter on our railroad is the manufacturer tools. Our employees sometimes like to manufacture their own tools, then they get injured, and that's a whole different problem. What you're probably wondering why there's a picture of a pigeon on the screen, because of this causation instruction under FELA. And it says railroad caused or contributed to cause plaintiff's injury or death if railroad's negligence played a part, and this is critical, no matter how small, in bringing about the injury or death. That is, we talked earlier about the diminishment of tort law under FELA. This is it, no matter how small. So how small is small? It's real small. The courts, and there are a number of courts that use this quote in saying that numerous FELA actions have been submitted to a jury based upon far more tenuous proof, evidence scarcely more substantial than pigeon bone broth. We had personal experience with this it's been 12 years already, where one of our employees was putting just a standard fence in a rail yard, chain link fence. He put the cap on the fence. The wind kicked up, blew the cap, plunked him on the head and a shoulder, and he claimed injury. We took that one, we lost, as you can see. We took this all the way to the Seventh Circuit, and the court agreed with the plaintiff that we didn't provide him with a safe place to work. When we speak of damages, there are three types. There's economic damages, those damages that are easily calculable, medical bills, out-of-pocket medical expenses, deductibles for treatment, those kind of lost wages, of course. Then the non-economic damages, these are not easily calculable, physical pain and suffering, emotional distress, loss of normal life, things of that nature. And the third type of damages are punitive. A lot of times people are not healthy in general, and it's certainly true on the railroad as well. And they come to us with pre-existing conditions. Doesn't matter. As you see here, plaintiffs are entitled to compensation for any aggravation of a pre-existing disease or physical defect resulting from the injury. And it doesn't matter if the pre-existing condition made the plaintiff more susceptible to injury than a person in good health. The railroad is still responsible. Let's put it this way, the courts give us an opportunity to say 50% of this was pre-existing, 50% of that was not. If we can't make that distinction, or a doctor can't make that distinction, then the plaintiff is entitled to everything. Strict liability. These come from the acts we talked about earlier, the Safety Appliance Act, the Locomotive Inspection Act, and the Boiler Inspection Act. while all railroad worker injuries are brought under FELA, a violation of any of these acts supplies the wrongful act necessary for liability under FELA, and the question of the railroad's negligence is not involved. So all those things I told you before about duty and breach of duty, and that doesn't matter if the railroad violates one of these safety acts. Once a violation is established, only a causal relation is an issue. Congress has directed liability if the injury resulted in whole or in part from the railroad's negligence. The next section, there are two categories of violations under strict liability. Under the Safety Appliance Act, particularly violations are either statutory or, as we mentioned earlier, they arise out of the regulations that were promulgated. So the pigeon is back. If the railroad caused or contributed to cause plaintiff's injury, if the violation of act played a part, no matter how small in bringing the injury. So again, if there's the tiniest thing that can be construed as a violation of a federal safety act, we're going to have liability. Under the Locomotive Inspection Act, the act imposed upon the railroad the absolute duty to have every locomotive used or permitted to be used on the line in working order. Again, not considering negligence, it's strict liability. The Locomotive Inspection Act further provides that the statute, or it says specifically that neither negligence on the part of the employee nor the absence of negligence on the part of the railroad is a defense to liability under the act. In other words, the courts don't consider whether you were negligent. If something happens that can be construed as a violation of these safety acts, the railroads are responsible. Adding to that, we spoke about contributory negligence and other forms of liability earlier. Contributory negligence of the plaintiff shall neither bar recovery nor reduce the amount of the plaintiff's damages. So once you have that violation of a federal safety act and strict liability attaches, doesn't matter what the plaintiff did. There's no contributory negligence at all in these things. Under the Safety Appliance Act, the employee shall not be held to have assumed the risk of his employment in any case. So even if the employee knows that there may be a violation and continues to do his job without stopping, that doesn't matter either. What can an injured railroad employee get? Well, he can get disfigurement, disability, both past and future. He can get money damages for loss of a normal life, past and future. He's entitled to damages for the increased risk of future harm resulting from the injury, damages for a shortened life expectancy, if applicable, pain and suffering, of course, both past and in the future, emotional distress, past and in the future. And when you look at these large verdicts that you hear about, picture, in a 45-year-old railroad worker who gets these damages. And so it's not just, for the past couple of years since the injury occurred, it could go 10, 20, 30 years up to his life expectancy in some of these cases, which add up a lot. Again, with these cases, aggravation of a pre-existing condition doesn't limit recovery, and neither does injury from subsequent treatment. So if a railroad injures a railroad worker, say he breaks his ankle at work, and then he goes to a doctor who commits medical malpractice. As a result of the medical malpractice, the railroad worker loses his foot, doesn't matter. The railroad is responsible for that as well, because we put the railroad worker in the position to be subject to the medical malpractice. So, economic damages, past and future medical expenses, past and future lost earnings and benefits, past and future caretaking expenses, and necessary help. I read a lot of things just now. The issues that railroads face, as these are line items on a jury verdict form. The more line items that the plaintiff's attorneys can put on the verdict form, it's just pure simple math. The higher the verdict is going to be. One of the things that is occurring now has to do with life care plans. Experts for the plaintiff testify, and they're very detailed about what the plaintiff is going to need in the future. And I've seen some plans that go down to how much aspirin the person's going to use, how many possible future surgeries this person may have, how many times he used to cut his grass, now he can't, how many times his lawn is going to be cut. So all of these add to the total number of damages. The last type of damage is punitive damages, and for that, we need willful and wanton conduct. And this is a course of action which shows actual or deliberate intention to harm, or if not intentional, shows an utter indifference to or unconscious disregard for the safety of others. One of our instructions for punitive damages says, if you believe that justice and the public good require it, you may award an amount of money which will punish the defendant and discourage it in others from similar conduct. The jury instructions require the jury to answer three questions. Question one, how reprehensible was the defendant? So when I say defendant, if I forget, just in your mind, insert railroad in there. How reprehensible was the railroad's conduct? Consider the following: the fact and circumstance of the railroad's conduct. Okay, the financial vulnerability of the plaintiff, the duration of the misconduct, the frequency of the defendant's misconduct, whether the harm was physical as opposed to economic, and whether the defendant tried to conceal the misconduct. The other two questions are what actual and potential harm defendant's conduct caused the plaintiff in this case. And number three, very important, what amount of money is necessary to punish the defendant, railroad, and discourage defendant and others from future wrongful conduct. There's this one says the punitive damages must be reasonable, but again, there's no real guidance for that. So for the last few minutes here, I want to talk about nuclear and thermonuclear verdicts. The current definition for a nuclear verdict is a verdict over $10 million, with the thermonuclear verdict being over $100 million. The Institute for Legal Reform studies these kind of things, and they found that from January 1st, 2013 to December 31st of 2022, the median nuclear verdict for all personal injury and wrongful death cases was 21.1 million, and the mean was 88.9 million. Preliminary data for 2023 showed the median nuclear verdict was 23.8 million. But in 2023, the number of reported verdicts greater than 100 million reached an all-time high of at least 23. And I spent some time on punitive damages for a reason, because thermonuclear verdicts typically, but not always, include a substantial punitive damage award. 13 of the 14 verdicts exceeding $1 billion during the Institute's 10-year study were primarily punitive damage awards. These cases usually involve catastrophic injuries, of course, or deaths. 4 states, California, Florida, New York, and Texas, have half of all the nuclear verdicts in the country. Florida has the most nuclear verdicts per capita, while California had the most nuclear verdicts from 2013 to 2020 at 199. There are a number of factors influencing nuclear and thermonuclear verdicts. Briefly, one is the reptile theory. This is a often studied thing in the law. The basic theory is that within our brains, we have a little part that's left over from tens of thousands of years ago. It's a reptilian brain that we have, and it's designed to protect the person. So the argument in a jury trial is, look what the railroad did. Look how they harmed this person. This could happen to you. You could be that person at a grade crossing. You could be the person, that was hit by the train, or your child could be hit by that train. And the theory is that it appeals to the subconscious element in your brain, and that's going to say, whoa, that's not good. We're going to punish the railroad because of what happened, because now I feel safe. My community isn't safe because of the railroads. Another technique or another influence is anchoring. So you tell the jury, oh gosh, he broke his ankle, that's really bad. Give him $5 million. And now the jury has in its mind, well, $5 million. Well, okay, let's start there. That's where our discussion point will begin, because they have that number in their mind. Combining trials of multiple unrelated plaintiffs, sure, you see 10 people sitting in front of you in unrelated cases, or there's some similarity in say, toxic exposure, the verdicts are going to be higher than if one person was sitting there. Advertising is contributing to this, as well as post-pandemic hedonism. The thought there is, wow, we almost died during the pandemic. Life is short. Let's give this guy $10 million so he can just have a great fun-filled life. Anti-corporate feelings are very much present today, especially with environmental concerns. So that's an influence. Social inflation is simply inflation that is above and beyond what you would expect from economic inflation. So if you would expect a verdict of 3 times in economic, like medical bills of $100,000 instead of like 3 times that pre-pandemic, now you can expect 10 to 15 times that. Another influence is litigation funding. This is where the plaintiff's attorneys, it's really like an investment in a way. There are companies and individuals out there that fund the plaintiff's attorneys in the plaintiff's cases in experts and things like that, where they didn't before. The idea there, and this has been approved by the courts, is it's nothing more than leveling the playing field, because insurance companies and large corporations and railroads, they can throw millions and millions and millions of dollars into the defense of a case, but a middle-class person can't. But now with litigation funding by these companies and people that invest in the outcome of the case, the field is now leveled because everyone can afford the expensive experts. Lobbying, there's a strong plaintiffs lobby. I'm a defense attorney, been a defense attorney for decades. This is my opinion only. We do a poor job at lobbying for laws that help our industry. Community involvement by the plaintiff's attorney. This is interesting. It's big here in Chicago, where you see plaintiff's attorneys advertising on television, and they're like reading to children. And there's nothing wrong with this. That's fine. It's good to read to children. They support softball teams and baseball teams. And I've heard in other areas of countries, they build libraries and basketball courts and tennis courts. And so now there's a case in court with this plaintiff's attorney who's contributed so much to the community. And yeah, I think there's probably some type of bias. They're like, oh, look what he did for us. He built us a library. What did the defense attorney do or the insurance company do? And the answer is usually nothing. Okay, managing risk. So you can retain a portion of the risk either through self-insured retentions or captive insurance. You can transfer the risk through traditional insurance or excess and surplus lines. And this is where the lobbying part comes in. You can hope to have state and federal liability caps. Currently, the federal liability cap under the FAST Act, which is Fixing America's Surface Transportation Act, is $323 million. That's the cap on liability for us. To mitigate these risks, certainly effective claims management is important. I believe in early settlement of a case, if possible. And in many cases, while you shouldn't automatically pay money, you have to pick the right case to try. But basically, the goal would be to stay out of court for the most part. And a good way to do that is to explore alternative dispute resolution through arbitration and mediation, and again, broader scale tort reform. And just one more slide on contractual indemnity. This usually comes up with trackage rights when, as commuters, we're usually on someone else's tracks, at least for part of the rides we provide. These trackage rights usually require the commuter to indemnify the railroad for anything that happens while on their tracks. Traditionally, the striking train is at fault. These indemnity agreements may alter that in some way. Purchase of service agreements, again, true indemnity. With our contract carriers, we indemnify them for whatever happens while they're operating trains on our behalf. There's a theory of but-for liability, but for the fact that they're operating our trains. This is purchase of service now, but for the fact they're operating our trains, they wouldn't have a train in the area where they struck a person. So without us, there wouldn't be any liability, and therefore contractually we need to indemnify them. And there's also a system of mutual indemnification, which is I feel basically a no-fault provision or concept where we each take our own damages and injuries. And that is all. So thank you very much. You may have some questions. I would invite you to email me, call me. There's my desk phone and cell phone. Thank you very much for your attention this afternoon. It was a pleasure to be here.
Thank you. Excuse me. Thank you. I really appreciate this. Is there anything that the Commuter Rail Coalition is asking Congress to change? And how would that impact the ability to provide more or less train service across the country?
Yes, the Commuter Rail Coalition is very active, both on a state and federal level. I think it was in May of this year, Mike Nolan, who's president of NICB, the South Shore Line in Indiana, and other executives from the commuter rails, I think, from Philadelphia and Los Angeles, testified before Congress on many of these issues, from insurance to the liability caps.
And how do these issues, because my understanding is it's difficult to get new service started in part because it's hard to get insurance. Why is that, and what needs to change in order to make that easier? Or is that even correct?
No, that is correct, Rick. I always use the example of there's a good chance this week or next week you're going to get a postcard from State Farm or Travelers or some insurance company saying, buy my insurance. the rail industry is deemed to be a high risk, even though it's not statistically, it's not a high risk. It's deemed to be a high risk injury or industry. So we don't get postcards to buy their insurance. We have to go to them, and we meet with underwriters every single year. Me and my team go. We market Metra to these companies. We ask them to invest in us to become our partners, and then they think about it. Unfortunately, in the United States, there are, I don't think there are any insurance providers that do commuter rail anymore. So to get this insurance, we need to go outside to larger markets like in London and Bermuda. In the last couple of years, we found a great market in Munich to get our liability insurance. So you're right. There's a capacity issue that is shrinking. Many insurance companies that used to insure commuters, especially insurance companies in the United States, they don't anymore because of the perceived risk. And then those who would say, okay, we have $10 million, we'll get 5 railroads, $2 million each in coverage. They've shrunk. Now they say, oh, we only have $5 million to share amongst the railroads. This year, I think we were approached by 3 or 4 major carriers that simply said we either want out of the Metra account or we want to reduce how much we can provide insurance to. So it is a big problem.
So what can Congress do to fix that?
I think liability caps are a very important thing. What we have asked Congress to do in the past was, because we talk about different things, like pooling liability, different railroads coming together under one risk program. We've talked about captive insurance. Some commuters have them, some don't. But there was a big crisis with insurance 2020, 2021. And we thought that was the best opportunity to go forward and speak to Congress with the idea that if we form some type of self-insured risk system, that we may need a backstop. Because while we're building our reserves, something may happen. And Congress, would you mind, like you have for other industries, like the nuclear industry, you know, there's federal backstops for these issues. Would you be interested in doing that? And they're talking about it, but we haven't seen any finality there yet. We keep going back often to Washington to keep in touch with them and lobby them to do that. But part of the problem, and it's a good problem to have, I guess, is that we are a safe industry. So, I mean, this is my opinion, but sometimes Congress might look at us and say, well, there are other things we can do with our money than provide a federal backstop to the rail industry, which is, I can understand that, but that's really not helping us solve the problem of the potential liability should we need to address it.
So liability cap, and then perhaps helping with backstopping for the.
Yeah.
And then is this issue different for Amtrak than it is for the other passenger railroads?
It is, and it is an Amtrak, as you know, is its own beast. It's very different. They are subject to the same insurance markets that we are. So any difficulties that we have with insurance, they have. They do have the protection of this FAST Act now, like we all do. So yeah, but they're still a special entity. It's not like a Metra or a SEPTA. You know, it's the National Railroad. So I believe they're in a different position should they have an issue than if we had an issue.
Okay. And then the last one I had was, I understand there's some issue with all of the passenger railroads have to go to the market at the same time, which causes a severe problem.
It does. It's with the FAST Act. It's coming up. It's coming up again now. So, and the FAST Act started off at a $200 million cap. And it was tied to an index so that every 5 years this thing goes up. And it's just simple math, right? If you're at 200 million now and you add 50 million, and then you have to do another 10%, another 10%. I mean, we started out 200 million, we're at 323 million. Now, because the number is so large, it looks like it's going to go, in much higher than that, into the $400-500 million in coverage. It's a cap, and that's what gets a little confusing. You don't have to buy insurance up to the cap. That protects you. So you can, if you're feeling lucky, you can not do that, and you could not have that much insurance. But for Metra in particular, and I'm sure a lot of other commuter railroads, we do have trackage agreements. We do have purchase of service agreements. We do have agreements with the PTC providers. All of those agreements require us to insure them as additional named insureds up to the cap. I mean, it's a good idea anyway to insure up to the cap, but they make us do it. If we don't have it, we're not going to provide PTC, or we're not going to run your trains. So yes, the problem then becomes, say I may need another $100 million when this thing goes up in a couple years. Okay, SEPTA needs it too, and so does MTA, and it's all going up at the same time. It's not staggered. So you have 20, 30, 40 railroads or more trying to get this extra $100 million in insurance at the same time, and that is a big problem.
So is there some way of staggering that?
That's one of the things that CRC talked to Congress about a few months ago. That certainly to me is the simplest solution, but we don't have that yet.
Okay. Chris, were there any other questions?
There are a few. We only have a couple minutes. But first of all, John, thank you for such an informative and interesting talk. We had thermonuclear verdicts, reptile theory, Hedonism. I love it. Do you have any? This is a question from the audience. Do you have any comments on the testimony from Mike Noland, the president of NICTE, also known as the South Shore Line and chairman of the Commuter Rail Coalition, about requiring a huge increase in insurance coverage?
Yeah, I think his testimony was correct. I thought he and his colleagues that met with Congress a few months ago were spot on with what they presented.
Thanks. Also, Ted asks, why should it be presumed that a moving train should be responsible for a collision? Trains are on tracks and protected rights of way. Other vehicles or pedestrians should be able to avoid being hit.
They should. So when we talk about third-party liability, there is something called federal preemption. So, for instance, a Metra grade crossing that has been approved either by the FRA or by the state of Illinois ICC, it's preemptively fine. You can't get sued because this is the setup you have, the design of the grade crossing. Where we can be sued are allegations of our engineer did not slow the train in time, had he been paying attention. Any of a number of things that talks about the train operation as opposed to design. Now, one of the best things that ever happened, well, two best things that ever happened to us is when about 20 years ago, we installed cameras on our trains to catch people who drive around the gates, or pedestrians who go under the gates, or pedestrians with headphones. The second best thing we ever did was put cameras that were inward facing on the engineer. because you get these allegations like, oh, he wasn't paying attention, but then we have inward facing cameras that show that he was paying attention and that he reacted as fast as he could, in addition to the downloads. So yeah, in a perfect world, the litigation has gone down because of those laws and something as simple as cameras. But yeah, unfortunately, we still get sued for those reasons.
It's 1 o'clock now. Do you have time for one more?
Sure.
Okay, thank you.
Yeah.
Is there any more to say about how facilities like train stations come into this? For example, boarding some trains sometimes requires passengers to walk long distances along platforms beside engines that are really loud or giving off exhaust, some of the hazards that you talked about. It seems at times like there's a non-zero risk there. Now that the infrastructure funding is providing chances to modernize facilities or build from scratch in some cases, does the law have anything to say about how to go forward?
The only law that I'm familiar with about that is like ADA laws. So when we change these platforms, then we comply with the ADA. So for an older station, some of ours are 100 years old, we don't have to comply with ADA because it's too expensive to rehab. Metra has over 240 stations, so to bring those up. In terms of train operations, sure, I mean, we have signs that say don't cross tracks, and we're installing signs now that are electric, so they blink and they talk at you. Are we still going to have people saying, I'm not going to pay attention and I'm going to go anyway? Sure. Are they going to write? They just, well, it's human nature. I don't know what it is. We see, some of our grade crossing accidents where cars are stopped safely where they should be, and at the last minute, for some reason, they hit the gas and they drive in front of the train. It's just, I don't know why. They don't back up. They don't back away from the tracks. They try to beat the train. And it's just, I've seen it so often. I always wanted to hire like a human factors guy to say, why is it that we have as humans a tendency to move forward quickly rather than just back up? So yeah, I don't know. I'm not sure there's that much we can do in redesign of platforms and controlling the traffic. Sure, we could add more safety things around a station. We've had suggestions of why don't we fence the tracks in? Well, you can't because of the grade crossings. And in Metra's case, we have about 1,200 miles of track. So that would be virtually impossible to do. Plus, you still need the openings for vehicles to drive through. And sure enough, people will use those on. So there's only so much you can do, I think.
Okay. Well, thank you again for your talk and for giving us a few extra minutes. Rick, and thanks to everyone for being here. Rick, any concluding thoughts?
No, just, thank you again. I really appreciate this a lot. This was very helpful. If you enjoyed this presentation and would like to have more of it as a listener, please go to highspeedrail.us and click the Join Now button or the Donate button. We are supported by members like you as we help you advocate for trains to your communities. So thank you for joining us. And John, thanks again for being with us. And we look forward to talking again.
That sounds good. Thanks for having me.
Thank you.